Okay, so we'll call the meeting to order at 7 p.m. We will have John Dilworth set in for Tom tonight. And that's the only one we have, I guess, as an alternate. Are there any additions or changes in the order of the agenda? Okay, we'll go as written. Are there any communications or correspondence?
Not tonight.
Okay, very good. So I guess the next thing is the audience of citizens. We can admit them, and we have some ground rules that I'd like to set here. Is everybody listening? Okay.
Yes, sir.
Yes.
All right.
Yep.
First of all, I'd like to say good evening, everyone. We will start the meeting with the audience of citizens as shown in our schedule. Please observe the following conditions. And we do appreciate your questions and concerns, and we'll try to answer them as best we can. Here are the conditions. Please limit your questions to 3 or 4 minutes, preferably 3 minutes, but you can go up to 4. Ask questions only pertaining to IWWC concerns, and speak slowly and clearly, and give your name and location before you start speaking. And that's about it. After we have the concerns and questions by you, we will take a vote on whether we consider this application to be a administrative approval. So we'll take a vote on that after we hear from everybody that has questions. And Isabel, why don't you start by giving us a background on the application?
Sure. So if it's all right, I'd just like to check in and make sure that no one in the audience of citizens is here to talk about something other than Cardsmill. I think that most members of the public here, not related to a separate application, are here to discuss the appeal. But if anyone else has another concern or something they'd like to bring up at this time, feel free to. I'll just give anybody a moment. And if not, then I think, John, maybe we should officially move it to new business, and then Ken can give us a rundown of any other information that the commission might need before I kind of introduce the application as I approved it, if that's all right with you.
Yep, fine. Okay, Ken, do you want to give a background?
Sure. Under the Wetlands Act, there is an ability that your commission delegate to an agent the ability to make determinations that an activity is not going to result in any impact on the wetlands. And if it makes that decision, the person who's the applicant should publish notice of that to enable people to take an appeal to the Superior Court, but also actually appeal here. And that allows your commission to essentially review what, it's an appeal. So the person who's brought the appeal really carries the burden. But what's going to happen in the hearing is your agent will present the information that she reviewed and for rendering her decision. And under section 12.1 of your regulations, which ties to general statutes, the agent can find that and I'm quoting now, that the conduct of such activity would result in no greater than a minimal, there's actually a typo in the regs that says that a minimal, but obviously than a minimal on any wetland impact on any wetland or water courses, provided the agent has gone through the training. And then in section 12.2 of your regulations, the applicant is to publish notice, and it enables persons to take an appeal to this commission, which is what your agency, which is what you're considering tonight. And it allows the person who's appealed to appear and be heard. And once you've heard the information, in your discretion, you can sustain your agent's decision. You could alter it. You can reject it altogether. And you can specifically require that an application be filed to come before your commission. Now, in some contexts, appeals are deferential, that you're not supposed to interfere with the judgment of the decision maker as long as they had some basis for their decision. This is not one of those cases. This is more like when a zoning board of appeals reviews a zoning enforcement officer's decision. They step into the shoes of the zoning enforcement officer, and based on the evidence of the hearing, they make their own decision. The Latin word for it is de novo. So in this case, you're going to hear the evidence, and you have the discretion yourselves to determine whether the activity that's proposed, in fact, does not involve anything other than minimal or no greater than minimal. So obviously, no impact would be no greater than minimal, or greater than minimal, or you could make another determination. They're really, in this particular case, she'll present her decision if there were conditions, if there were things that were on there that you thought should be modified. That's the ability to alter her decision. But in a case where she's made the determination that there's no more than minimal impact, the key here is for you to decide whether, based on the evidence, that you agree that was correct. And if not, then there would be an application requirement, and you direct the person who's received the determination to file an appeal. You have any questions about that process? And another detail is, after the enforcement officer basically, or the wetlands agent, presents the information about what she reviewed, the order I suggest would be to hear from the person who's filed the appeal. Any evidence that can be presented there would then be subject to, a rebuttal presentation by the owner of the property that obtained the determination, and they can present information. There's no, it's a hearing, so unlike the situation of the audience for citizens where you limit 3 minutes, in this context, the persons who filed an appeal, or the enforcement officer, or the person who obtained the determination from the agent, should all be allowed, as long as the material is being presented as material. The chairman can always rule that it's immaterial and direct them back to what you should be considering. As long as it's material, they're not subject to a 3 or 4 minute limitation presentation.
Okay, thank you.
And I just have one more question for you, Ken. I actually don't see Lisa King, who is the applicant who filed the appeal, in the meeting. I sent her the meeting information, but I don't see her present here. So I don't know if that changes anything, or if you have any comments on that. Or Lisa, if you're in the meeting with someone else and I'm just not seeing you in here, feel free to speak up. Be good to know if you're present. No, okay.
Well, that's important, because the only reason you're here is the request for a hearing,
Right.
to allow that person to appear and be heard at the meeting. It's not a method in which your determination is, because gets gets sort of wiped clean, and the commission now gets to decide it all over again, it's an appeal. So I know you indicated earlier your expectation was to present what you reviewed, but if you don't have an appellant here to appear and be heard, there really isn't anything for the commission to do. So I don't know if you want to pass it or whether you move on, just move on. If you have to make an inquiry, maybe the appellant is in under a different name and should raise hands, but if the appellant's not here, then I don't know that you need to proceed any further.
Okay.
I'll just add that we have Joseph Stumpf in the waiting room, and it says joining next to his name, so I think he might be having trouble loading or something. I don't know whether to expect Lisa King to be with him or anything like that.
Well, he is not the applicant, though.
I would not.
He isn't the one that,
Right.
okay.
Just wanted to point that out.
So I think that's what Ken is saying.
Okay.
So if nobody is here to defend it, I guess we can go on with other business.
Okay. I know we do have some other members of the public here, I think. I see Carol Briggs is here with her hand raised.
But it's not
the applicant or the.
it's not a public hearing. I mean,
Right.
if the person who filed the appeal had witnesses, had evidence that they wish to present, then in the nature of other persons, then that could happen. But if you file an appeal, in a court, for example, and don't show up, the court doesn't start just receiving evidence from other people. So the person who's filed the request has a right under section 12.2 to appear and be heard. That's unlike a situation where your agency determines that something's a significant activity, in which case you have to have a public hearing, or if a petition is filed, to have a public hearing on an application. In that case, any member of the public is entitled to be heard.
Right.
The only person entitled to be heard tonight and is the appellant and any other person that is presenting evidence on behalf of the appellant. So you might, make a last call, but if not, I think you can you need not take any action on the appeal because no evidence was presented, and or I actually, better yet, I would recommend you because no evidence was presented to regarding the decision of the hearing officer, you could deny the appeal.
Okay.
Would that require a motion to deny the repeal? Appeal?
That's my suggestion. You've got an agenda item on, and you've given, it's there. It's the appeal, giving a person a right to appear in light of the fact that the person has not appeared to be heard. You essentially denying the appeal by default. It was it was the appellant's obligation to come and present information on why the agent's decision should be reversed. It's not a do-over, whereas you push that button and the commission has to make its own decision. It's an opportunity for the person who's filed an appeal to be heard. And if that person's not here, then my recommendation is make a motion that because she has not attended and presented evidence in support of her appeal, the appeal is denied.
Okay, very good. So, Mary, did you want to make a motion?
Well, I just one other comment. I do believe we have a couple of other things tonight, just as a courtesy, in case this person cannot get on or may be late. Maybe we should deal with the other two applications or reviews required and go back to it. If that person does not come on, I think Lisa King was the name.
Mhm.
Then I think we go to a motion to deny appeal. But
Okay.
let's
I
give her
agree
some
with that,
time.
Mary. I agree with that, too.
Okay, we'll do that then. Okay, let's go on.
And Mr. Chair, if I could ask, Ms. Kislik, do you have email access while you're in the meeting?
Yes, I do.
Yes, okay. So what I'll do, just to save the town from, I don't think you need my assistance in the other matters. So what I can do is I can just shoot you my cell phone number. I'll leave this link on mute. And if you need, if she comes back and we're going to start a hearing, give me a call on the cell number. And if I don't, I wish you all a lovely evening.
Okay.
Thank
All
you.
right, yes, Mr. Chairman, before Mr. Slater leaves, could I just make a couple comments? First of all, my name is Mark Brulard, I'm a lawyer in Woodstock. Good evening all, and good evening, Attorney Slater. I did send a letter of representation to the office today, and I've been representing the applicant before the Planning and Zoning Commission. While I certainly think it's not inappropriate to allow a reasonable amount of time to see if this applicant is going to come forward, I don't think we want to, I don't know how long your other business is going to be, but I don't think we should wait an hour or two for this applicant to show up. I mean, if you want to give her 10 minutes or 15 minutes, but I mean, this is similar to a court proceeding, and, you know, there's designated times, and we're now 15 minutes past that. So I would ask that, you know, maybe we give 10 or 15 minutes, we come back and 15 minutes, if we haven't heard from her, then I think at that point, the appeal should be denied and the action of the agent sustained.
Okay, so we'll give her 15 minutes, but we'll go on to other business while we're waiting,
Oh,
okay?
certainly. I just wanted to, I appreciate the opportunity to address the commission and just wanted to give you our position on this.
Appreciate that.
I will say I just admitted one more person from 617-8942. I don't know whether that's the person who filed the appeal or someone else.
Why don't you, can you contact her?
She is contact the person at that number or contact Lisa King.
This is the person at that number.
Yeah,
Hi.
Hi, my name is Joe Stump. I'm the person at that
Oh.
number.
Oh, okay. Thank you very much
Okay.
for identifying yourself.
okay, so it's not her.
Yeah, we saw you trying to get into the waiting room and having some trouble, so.
I'm trying to get into the video portion of the meeting and I'm having difficulty, so I'm on the phone.
Okay.
Okay, very good.
Thank you.
Okay, you're welcome. So Josh, will you give us 15, tell us when the 15 minutes is up, and we will continue under new business here, okay?
Okay, I will.
I'm sorry, we only have
So
one
if
thing
we're-
under new business.
So if we're
Okay,
in if
so
we're in the
we'll go
middle
on
of
to old
a
business.
if we're in the middle of an old business item when the 15 minutes are up, do you want to just interrupt that or?
Yeah, let me know, and then we'll finish up in a hurry and then let them get on.
Okay, I have started the timer.
Okay. Okay, under old business, IWWC 2122-36, the application of Bob and Cynthia Muska to paver patio and add a drainage trench and gravel extended storage area at 21 Lake Road. And I know we went on a site walk to see that, okay? Isabel, you want to give us an update on that application?
Sure, absolutely. So we did go on a site walk this last month, I believe on the 16th, to review the location. I do not see Cindy or her husband present currently, or anyone representing the application. So if you're present, again, feel free to,
Or was that Muska?
yes.
She was on, I seen her on the screen. She was on a little while ago.
Did you? I haven't seen her on today. I did email her the meeting information, and I have reached out to her to see if she had decided on a new location for that wood pile that they currently have placed in the wetlands that we were discussing at the site
Right.
walk. So just to give an overview for anyone who wasn't present at the site walk or anyone who just needs a memory refresher. The Muskas put a patio in place behind their garage. They also placed a pipe drainage from the wetlands to the road along the side of their driveway. And they extended an existing gravel area slightly on the side of their garage as well. The work is currently complete and everything is stable. So there was a notice of violation sent out for this when we the commission went out to review everything for the site walk. We did see that there was a woodstock pile in the wetlands area and a stone pile in the wetlands area, which we discussed that they would need to move, and discussed where they could potentially move it. I have since reached out to the Muscas to discuss where they could place that wood pile, because I know that they were a little bit confused over the best location, so that it would definitely be out of the wetlands. But I haven't actually gotten back to the site. I haven't heard back from them yet at this time to see where they would like to move those that wood pile. The other thing that we discussed at the site walk was a potential vegetative barrier between the extended gravel area along the side of the driveway and the wetlands, just to provide a little bit of a buffer and protection, and prevent them from extending that gravel out any further, and to safeguard the wetlands a little bit. Up to this point, I have not received any updated plans from them.
Okay, very good. Do we have, anybody want to speak on this subject at all?
So John and Isabel, this is Ian. If they haven't updated the permit, can we even act on this yet?
Well,
Because I don't think the permit that at least was that was in the package addressed the items that we talked about in the field. So
No, it did not address the native plantings or the wood pile and the new location for it. So because I haven't gotten out to the site to see where they'd like to move that, and because we haven't received any update, I think that this is something that's maybe going to have to potentially continue.
So we don't have a summary ruling on that?
I do have one prepared if the commission would like to take a vote on it at this time, without the applicant present, but
I think we
I
could
haven't
do it
received any
because you,
confirmation.
yeah, because you could include those two items under your summary ruling, right?
Yes.
Okay, why don't we do that?
Before you do that, I just want to make sure people are seeing the message that Carol Briggs just sent in the chat feature
Just saw it.
on here. I know this isn't 15 minutes yet, but I did get a message from Carol Briggs in the chat feature here on Zoom saying Lisa King's email doesn't work. She did not receive the notice, and Carol is speaking with her by phone.
Can she call in?
I'm just sending a brief message to Rich, or to, I'm sorry, to Ken, to let him know, and because Carol is present, then that's maybe something that we'll address after we settle on the Musca application, I think.
I just
Sounds
wanted
good.
to make sure you were aware of that.
Thank you. Yeah, I am sending him a quick email. Just 1 second, I'm sorry. Okay. So I will go to that summary ruling just to discuss it. And I have, let me see, the standard conditions of approval. And I did include the native planting barrier. Let me see, and the removal of wood and stone. If I can find it. And then if
Okay,
commission members would like to make any adjustments, we can do that at this time as well.
very good. Could you read, Isabel?
Yes. So this is for IWWC 2122-36, the application of Cynthia Muska, 21 Lake Road, to install a patio drainage tank with a pipe and to extend the gravel alongside the garage within the upland review area. I'm going to bypass the standard conditions of approval. Nothing has changed outside of normal. It is a permit for 2 years, unless completed earlier. And I also included
Connor, can you go check the dryer, see if it's running?
number 6, all activities for the prevention of soil erosion, such as silt fence, hay bales, and other necessary or required measures, shall be under the discretion of the wetlands agent or contractor, who shall employ best management practices consistent with the terms and conditions of the permit. The wood pile and excess stone will be removed from the wetlands and stored in an area approved by the wetlands agent. Native wetland vegetation will be planted as a barrier between the wetlands and the gravel bed by the garage. And Cynthia Muska is assigned the responsibility for implementing the erosion and sediment control plan. The responsibility includes installation and maintenance of sediment control measures, informing all parties engaged on the construction site of the requirements and objectives of the plan, and notifying the Wetlands Commission of any transfer of this responsibility, and conveying a copy of the erosion and sediment control plan if the title to the land is transferred.
Okay, so does we want to make a motion to accept Isabel's summary ruling?
I make a motion to accept the summary ruling as read.
Okay.
I'll
Do we have a
second it.
Okay. Any discussion? Okay, all in favor, raise your hand.
Wait a minute, wait a minute, wait a minute, wait a minute.
Oh.
I have some discussion. I
Oh,
just had to get
okay, yeah,
unmuted.
go ahead.
Should there be something stated that the permit will not be fulfilled until the wood pile and the rock pile have been moved?
It's already in.
It says it. It's in it.
It's in it.
Approved by the
but-
wetlands agent.
But our agent will keep checking and the permit will not be completed until the stone and the pile has been moved to a satisfactory location. Correct?
Isabel has the authority to stop it if the work doesn't get done, absolutely.
Yeah, and then it's not completed, right?
Right.
Okay, go
I
ahead.
can add that language if you'd like me to, Tip. To this point, most of the work has actually been completed and was completed before we received an application. So the only work to be done at this point is actually planting that barrier of wetland vegetation and removing the material from the wetlands, which I will
Right.
absolutely. do.
Yeah, I was on that site walk. I remember that.
Okay.
Okay, my concern is we want to make sure those two items do occur and that's something you will check.
Oh, yeah,
Okay,
absolutely.
go forward. I'm sorry.
Right. Okay. So we have a second, all in favor, raise your hand. Okay. Opposed? So moved. All right, next item.
Let's see.
IWWC 2122. Oh, do we want to wait on that until we find out whether the appeal person that did the appeal who is Lisa King will be able to contact us?
Yes. Just
Okay,
let
we'll
me
hold
give
up on the
Ken a
other
quick
one.
phone call, and we can get his opinion and maybe circle back to it and then go to the last application.
Okay,
So just 1 second, I'm sorry. Okay, Ken is gonna rejoin us and give his opinion here.
Hi, folks. So it was shared with me that the appellant has apparently called Carol Briggs, and hello, Carol, I hope you're well, and was going to communicate through Carol. If the appellant rather is able to call Ms. Briggs, then she should also be able to call the number on the agenda to be able to participate by telephone. There's nothing that would prevent her from making her case to you via that. Excuse me, that was my alarm for 15 minutes. So she should do that. So if Ms. Briggs wanted to share the number to call in, that's what should happen. It shouldn't be a relay, information that comes from the appellant to Ms. Briggs to the board. You need to hear directly from the appellant.
Okay,
I think she just joined us, actually. So.
Oh, there we go. Okay. Hi, Lisa. Can you hear us?
She's muted.
Okay. Lisa, can you hear us?
Hello?
There she is.
There we go. Okay, so should we move forward with this just by going over the application as I approved it?
yes. Why don't you give us a summary, Isabel?
Okay. So. I will pull this up. I'm going to screen share again, just so that everyone can see the application itself. So for those of you who are attending over the phone, just that's what we're discussing. Let me see. So the application was for the construction of a 60 by 60 event facility, 3 paved parking spaces, and the installation of portions of on-site septic within the upland review area of the 10 Mile River and the associated wetlands at 79 Cards Mill Road. Let's see. And I am going to go here. The area was flagged by a soil scientist, Joe Thoreau. He describes the different wetland delineation across the site. And it's also been surveyed and marked on the map, which I will show here. We have a brief statement of use and the alternatives that were considered. The applicant determined that this was the most beneficial spot to place the proposed building and associated facilities because they were the furthest from the river to the alternatives that were concerned, and they were already in a developed area, grassed area. So let me see, this is the parking section, which is completely outside of the upland review area. So I'm going to skip over that to discuss the 60 by 60 building, which was originally a concrete pad. And so for this application, the most recent one, it was amended to a full building, a turnaround, 3 handicap parking spaces, a restroom area, and then a pump line, which you can see here. which is for the septic system, and it is partially within the upland review area. The building and associated facilities are about 165 feet from the 10-mile river. The contours show that the flow path of runoff coming from the building is actually in the other direction, going up north this way towards the river, in a flow path greater than 200 feet. The area surrounding the building has been infiltrated by greater than an inch. The area surrounding the 3 handicap parking spaces also includes a stone trench to infiltrate runoff. And I'm gonna zoom in here so that everyone can see this a little bit more clearly. There is silt fence surrounding both the stone trench and handicap parking spaces, and surrounding the building and restroom on this side to better protect the wetlands and the 10-mile river. The slope itself in this area is very minimal. And looking at the site, I did not have concern that runoff would make it to the river and have an impact on the wetlands or the river. And certainly with these sediment and erosion control measures in place, I felt that this would have no greater than a minimal impact. This is the trench line for the pump for the septic system. Again, this is within the upland review area, but the most impactful aspect of this is the trenching itself, which will occur within a day and be backfilled and stabilized within the same day. And it goes up the hill towards the septic area, which is outside of the upland review area of these wetlands here. And just inside the upland review area, I believe, of the 10-mile river. But again, greater than 100 feet from any wetlands. The applicant also placed berms here to control runoff coming down along the side of the driveway, because there is a bit of a slope in this area, just to pay greater attention to any runoff concerns. Let's see. There will, again, even though this is outside of the upland review area, there will be silt fence surrounding the septic area and any stockpiles. And this shows a greater detail of the infiltration that will be surrounding the building. There will be infiltration here surrounding the parking spaces. So I am going to move on towards the approval that I issued. Actually, I did have a report as well from Ian Cole, a registered soil scientist, wetland scientist, and terrestrial ecologist. This was originally submitted for PZC because concerns were raised over the environmental impact of the project there as well. And he describes in great detail the vegetation, the soils, the wildlife that he saw when he did perform this review. And in his closing comments, he states that he feels this makes reasonable use of the buildable upland area, which was consistent with my separate assessment. And I think this is what I'd like to show everyone here. You can see how minimal the slope is. This is off-site by the 10-mile river, and that is the house that you can kind of see in the distance. This is the existing gazebo, which is near the proposed seating area, but that isn't involving any disturbance of land. And this is where the event facility building will be placed. And again, you can see that it is already developed and that the slope is pretty minimal. So that's why I didn't have a lot of concern over runoff reaching the river or over erosion and sedimentation. And certainly I think that with the amount of infiltration that the applicant has proposed, this will actually be an improvement on the site over runoff just from the grass into the 10-mile river. And I did have, let me see. Sorry, this is a long application. I did have some conditions of approval. Ultimately, the approval was for the 60 by 60 event facility, 17 by 23 foot restroom, 3 paved handicap parking spaces, a paved turnaround, and installation of portions of on-site septic, and then landscaping for the purpose of sediment and erosion control, so the berms and the silt fence. These are the standard conditions of approval that I am now using for administrative approvals, just to provide some additional documentation and guidelines for applicants, and give these a little bit more structure. The duration of the permit is for 2 years unless extended. And these are very similar to the standard conditions of approval that I issue for, or that I write for summary rulings for commission approvals, just a little bit less involved. So I can read these if anyone feels it's necessary as well, but I'd just like to kind of briefly go over that a pre-construction meeting will be held with the wetland agent and a project representative from Killingly Engineering to discuss the plans and review placement of the sediment and erosion control measures. So I'd like to review the placement of the berms, and I will be out there to verify that the trench for the septic pipeline is backfilled and stabilized the same day. Any excavated material will be removed from the upland review area immediately. At the end of the day, the trench for the pump line will be backfilled and soil will be covered with straw. The location of the landscape berms will be adjusted in the field by the wetlands agent just to control the runoff that's currently coming down the hill. And the septic system, 60 by 60 building offsets, handicap parking, and several locations along the pump line will be staked out by a licensed surveyor to ensure that all features are installed according to the plan revised April 20th, 2022. That is the approval that I issued, and then we have the appeal notice from Lisa. And at this point, I think we'll turn it over to Lisa to speak to her concerns.
Okay, very good. Before we do that, I would like to read the first paragraph of the person that did all this work. His name is Ian T. Cole. He is a professional registered soil scientist, a professional wetlands scientist, and a terrestrial ecologist. And the first sentence kind of sums everything up. It says the proposed layout makes reasonable use of the available buildable upland space on the parcels while maintaining the integrity of the nearby environmental receptors. No regulated jurisdictional inlands, wetlands, or watercourses will be directly or indirectly impacted as a result of the proposed activities, okay? I just thought I'd read that. Okay, now we can hear from Lisa King.
And just to confirm, would you like me to be holding everyone to 4 minutes? Is what you said?
Yes, please.
I think for Lisa, as long as she's speaking to the topic of the application and the impact on wetlands, we can allow her to speak.
That's right. She,
Okay, that
yeah,
makes sense.
Ken Slater, for the record, her evidence or witness that she presents can speak for longer.
Hello,
Hi.
can everyone hear me?
Yeah.
Thank you.
We can hear you.
Yes, well, my letter is before you. I think it speaks for itself. I think Carol Briggs can best voice my objections. And so if you don't mind, I would like to give her permission to speak on my behalf.
It's okay with me. Yep.
All right.
Is she representing her? It's just a point of order. Is she representing her in a representative capacity as an attorney before this commission?
No, I'm not. She's just authorizing me to speak on her behalf.
Well, then what would be the, I would ask the town attorney, Mr. Slater, to determine whether or not that's appropriate. If you're not acting as an attorney, the applicant herself should present the appeal, not somebody else.
The town attorney has already said that she could authorize me to speak on her behalf when we first started this conversation.
Well, there's a subtle difference, and if what Ms. Briggs has personal information that she wishes to submit that supports, in Ms. King's view, Ms. King's appeal, then she could present information on that she has. Being an advocate, she would need to be people. That's what an attorney is a person who can speak on behalf of someone else. If not, it's unauthorized practice of law. So if Ms. Briggs has information related to the appeal that she has, then by all means that should be submitted. If she's there just simply to advocate a legal argument, then unless she's can legally do that, that would be as an attorney. Then that
I would be, if it would help them. Lisa, would you mind having me be a witness on your behalf, with help with regard to the information that I have regarding it?
And whatever you want to do, Carol, is fine with me.
Okay.
Is that fine with everyone else?
And all I would recommend to the chair is that Ms. Briggs presents information that's related, that she has, that's related to this appeal, that's permissible. But being, a legal advocate is not. So, and I think, Ms. Briggs is well aware of the difference. So with that caveat, I would suggest she be allowed to speak.
Okay. Yes, you can speak.
Thank you. I would turn my camera on, but apparently my tablet isn't going to let me. So I apologize for you speaking to a blank screen, but it's not letting me turn my camera on, and I don't know how. So it's just not giving me that option. So I apologize. A few points. If you look at the site plan, all of the work that's occurring down at what I'll call the bottom land area, I'm going to set the parking lot area aside. If you note, all of it is occurring immediately adjacent to wetlands or immediately adjacent to the river. And when this is done, basically that entire bottom land area is fully developed. There is no grassland left, other than the small areas that are within the wetlands, delineated wetlands areas. So this is all occurring in a regulated area. I do want to make the commission aware. This is similar to what happened with the last application. They already have a site plan that's different than the one that you're approving. So I bring that to your attention only because I do want it on the record that once again, the application you folks are addressing has a smaller footprint than the most recent one that the planning and zoning received from the applicant at their meeting on June 6th, I believe. No, June 20, sorry, I believe it was June 6th. I'm sorry, there's been so many application amendments, it's hard to keep track. But you folks are now voting on a site plan that doesn't exist in front of the planning and zoning. And it's a larger footprint. And even this is still a large footprint. I realize Ms. Kislyak did, did a thorough evaluation of it. But I do know that originally they claimed there were no wetlands on this property. And now, gee, magically they found all the wetlands that we complained about the first time. Their environmental person did a site investigation of wetland ecosystem in the middle of, in early spring, when everything's dormant. So his claim that there aren't animals there of special concern is really not a valid argument unless you're going to go out there in late spring or early summer when these creatures are actually moving around and visible. Looking for them in early March really isn't a very effective technique. So that report, while he claims will not disturb the wetlands or the 10-mile river, I don't know of any environmental person that would ever say will not. They could say more likely, not likely, but they don't give absolutes like that because he can't guarantee that. No one can. that area does flood. We had the discussion that on the other side of the river in the New London County, the flood elevation level is 280 feet. Because Columbia hasn't been mapped since 1982, it doesn't show it as a flood zone. So while there's a reference to the fact that the runoff will be minimal, that's because all be underwater. It won't run off, it will be underwater. So we're building up a large construction project in what is essentially what, if it got ever mapped properly, would be a flood zone, but if nothing else, is all within 200 feet of the 10-mile river, which floods. And I do know from historical fact that that property has flooded. In its prior iterations, when it was owned by Mr. Freeman, my in-laws family has lived in that area since the 1920s. That property has flooded repeatedly up to the porch line in various iterations of the house. So putting all of that construction in that area means that you're adding impervious surfaces, you are increasing runoff, you are decreasing the ability of that area to handle water in that area. It's buffer land. And that's how it should be protected. And this project should not be allowed to proceed through inland wetlands. Thank you.
Okay, thank you. Isabel, do you have anything to say?
There are some things that I could address, but I think at this time we might want to allow agents of the applicant to speak in response. If that's most appropriate, Ken, feel free to chime in, and then I can add after that. And I also see that David has his hand up.
Okay,
I think, Dave, we can't hear you. It doesn't look like you're muted, but.
While he tries to come back and we can address what question or comment he would have, I agree that turning it to the agent has had an opportunity to overview her decision. The appellant has given, had put her witness on, and the applicant who obtained the ruling should be given an opportunity to be heard next.
All right, thank you, Mr. Slater. Let me just introduce myself again. My name is Mark Brulard. I'm an attorney in Woodstock. I represent the applicant in this case. I only have a few comments, and then I'm going to turn it over to Mr. Norman Thiebaud, who's the engineer from Killenly Engineering, who's been involved in preparing the plans. And I would just note this, that what you just heard from the appeal is largely the opinion of Ms. Briggs. It contains her own personal opinions. It contains basically hearsay evidence that would never be allowed in a court of law. I understand that we don't, that the commission has more latitude in what evidence it receives, but I would urge you to not consider many of the statements because they're not supported by evidence. What you have before you and what your wetlands agent had before you were professional investigations done by licensed, experienced professionals that did a competent and thorough job. And I think there's been nothing that I've heard that would give this commission any reason to sustain this appeal. And rather, I think the decision of your agent, who's done a very good job, should be appealed. I'm going to have Mr. Thiebaud now answer any questions, particularly the ones about the change of the plans. There have been no significant changes in the footprint of the building. Any changes that were made to address concerns of the Planning and Zoning Commission, and they don't impact at all this application and don't, and in my view, shouldn't impact your decision whatsoever. But Mr. Thiebaud also, I believe, has an updated letter from Mr. Theo Soil Santos that I believe he submitted today to the office. So with that, I'll have Mr. Thiebaud identify himself for the record, and he will make any comments that he feels are appropriate. based on the application that he had a good deal of work in preparing. So thank you for letting me address you briefly, and I will now turn it over to Mr. Tebow. Thank you, Mr. Slater.
Thank you.
Thank you, Mark. For the record, my name is Norm Tebow. I'm a licensed professional engineer at Killingly Engineering Associates. And we prepared the plans for both the wetlands application and the planning and zoning application to the town of Columbia. What I will say is that the application that was submitted to the town and that Isabel ultimately approved as an agent approval was prepared with input from her as well as Mr. John Valenti, who at the time was in the process of transitioning out of his position in Columbia. And I met several times with both Mr. Valenti and Ms. Kozlik. We met on site, we met at the Columbia Town Hall, and the items that you see on the plans as far as taking steps to prevent or any kind of impact to the wetlands were the result of a lot of input from your staff. The total amount of activity within the regulated area is about 6,500 square feet. That's 0.15 acres. This is a 41 acre plus parcel. So if we look at it in mere percentages, it's about 0.3% of the entire parcel that is being impacted by this. This is a portion of the building is going to be within the regulated area that is constructed in an area that is currently lawn. It's a grassed area. Any of the roof runoff from this building is going to be infiltrated back into the ground so that we don't increase the amount of runoff. In my opinion, the way that the watersheds work and the way that I've always designed, I have quite 25 years of experience and a background in water resources engineering and hydrology. So I have a pretty good understanding about how these ecosystems work and how these watersheds work. And when you have a development like this, and you've got a large watershed up above you, several thousand acres that ultimately make its way to this site, what you want to do is not worry about how much stormwater gets to the river, but more the treatment of the stormwater, and make sure that you treat it properly so it doesn't impact it from a contamination standpoint. Because as you all know, if you have a large rain event, it's usually a day or 2 or 3 days later when you see these brooks flooding and the rivers flooding. So we want to make sure that we get the water away from this site quickly and before we get this big rush of water behind it. That being said, with 6,500 square feet of disturbance in the regulated area, it has really an immeasurable impact on what might happen to the wetlands in the watershed here and the 10 Mile River for that matter. We did work with a number of experts in the field, and I think Isabel read some of the comments by Mr. Cole. I believe you too, Mr. Allen, read his summary. I will say that there was a comment that he did this at the wrong time of the year. But what Mr. Cole does as a terrestrial ecologist is to look at the habitat. You don't necessarily need to count salamanders or tadpoles. You look at the habitat, the terrain, to see if there is such a habitat available on the property to support a species of concern or endangered species. We might note that the natural diversity database says there aren't any on this property. And we will construct the building in an area that is previously developed. We're not taking down any trees. We're not disturbing any fields. There is no evidence of vernal pools on the property, things of that nature. We also had Joseph Thoreau, who was the soil scientist who delineated the wetlands. And before I get to that, I just want to say regarding the wetlands that quote unquote magically appeared on the property. We did our work on the property, meeting out there. First of all, with Isabel at the commencement of this project, when we were just going to do a tent out there. And we had record mapping of the property that was on the town's land records, and the wetlands that were indicated on the plans that the town had on the land records. We made sure that we stayed away from them, and we had Mr. Thoreau investigate them. When we changed the application, when we came back in with a second application to put a building there in lieu of a concrete pad in the tent, Mr. Valente went back into the files that the wetlands department had, and he found a map in that file that was not on the town land records that showed additional wetlands on the property. Upon finding that map, he presented it to us, and we had our soil scientists go back out there to verify these areas. So there was no intention of keeping this from the commission or keeping it from the wetlands agent, because when we found out that there was additional mapping that was not on the land records that was presented to us, we went out there and took the proper steps, and we had that verified and delineated. To that end, I have a recent letter by Joseph Thoreau that I forwarded to Isabel this afternoon. And we had Mr. Thoreau review the plans and with regard to his wetlands delineation and take a look at what we were doing out there. This is actually addressed to my partner, Mr. Greg Glaude. And it says, Mr. Glaude, at your request, I have reviewed the site plans entitled Site Plan Number 2, prepared for Valley Street Investments LLC, 79 Cards Mill Road, Columbia, Connecticut, dated 10/12/2021, and revised to 6/23/2022 by Killingly Engineering Associates. I have also inspected the site of the proposed development. It is my opinion that the wetland delineation is accurately depicted on the site plans and represents the inland wetlands and watercourses and floodplain soils as they exist in the field. Concerning the proposed event building, driveway improvements, septic system, and force main, it is my professional opinion that the construction and operation of these features will not significantly impact wetlands and the watercourses on the property. It is provided that the proposed E&S measures are properly implemented, maintained, and inspected throughout the construction timeframe. In conclusion, if you have any questions concerning the inspection, delineation, or this report, please feel free to contact me. And that's signed by Joseph Thoreau, who's a certified soil scientist and a member of the National Association of Certified Soil Scientists. One more item regarding the flood zone here, because and this was presented in quite a lot of detail at the planning and zoning meeting, because there is the claim that this property floods, and that the new flood maps that were released for across the river basically should be reflected on this property. That is not the procedure that's followed. We have to go by whatever current flood maps are on file and what FEMA has at the time. If we do a lot of things called LOMAs, which are letters of map amendment, where we do investigations for people who, for instance, don't want to pay flood insurance. And what the FEMA's tool is for determining whether or not they can remove a structure from the flood is their current mapping, not what may be and what mapping may be presented in the future, or what mapping may be forthcoming. We use the industry standard that's available to us, and according to the most current mapping by FEMA, this property is not in the flood zone. There are some very small portions down the far end of the site where you've got a little bit of the river's edge that comes up and floods. But according to that mapping, it does not. And our conversations with the previous owner, who lived there for 14 years, I believe, said he had a couple of incidents where he had some water on the grass, but the water never came up to his house. He never felt threatened. He never felt endangered, and he raised 8 children there. I think that's all I have to say at this point. I think our application speaks for itself. We did have the qualified personnel provide reports for us, investigate the site, and I concur with their conclusions.
Okay, thank you very much. Okay, do we have somebody else that wants to speak?
John,
Anybody else?
John, this is Ian. I just have one question. In
Oh,
the
yeah.
and I guess this might be for Isabel or for Norm, is in the appeal, it specifically says we understand these activities would occur in a wetlands area and within 200 feet of a water course of importance. I know we discussed the within the 200 feet, but is there any work in a wetlands area?
No, there isn't. The wetlands were all delineated by Joe Thoreau, and you can see on the map, which I can pull up again if anyone would like to see that. All of the work to be done is in a currently developed area that is grass. Nothing is within wetlands, or I would have brought it to the commission because I would have considered that greater than minimal impact. And most of the work, or majority of the work, is greater than 100 feet from any wetlands, and certainly from the 10-mile river. So there is still a good distance, even though it's within that upland review area.
Thank you. Anybody else want to speak?
I know David had his hand.
Point of order.
Okay,
To build on Ian's question, if I heard her correctly, has said that none of this work is being done on wetlands, should this be considered by wetlands?
So I can speak to that as well. Ultimately, the reason that this was considered by wetlands is just because it was in the upland review area.
Sure.
And certainly that 10-mile river is in this regulations, the wetlands regulations for the town is an area of special concern. So it's got the extended upland review area. And that was why I initially went out to the site. Even before the wetlands were delineated by a soil scientist. Anytime I issue an administrative approval, I go out on the site to review it.
Sure.
And at that time, I can't delineate wetlands myself. I'm not a soil scientist,
Sure.
but I am certified as the wetlands agent and have taken that course. And I did identify wetlands areas around the river, which were later marked as wetlands by Joe. But nothing within the area that's being developed or impacted.
So nothing within the area that's being developed or impacted.
Yeah,
Is-
no direct digging or excavation or filling of wetlands. of
Okay.
any kind.
Thank you.
okay. Do we have any other questions from the audience?
I think David had a question. Sorry, I think you're getting cut off there a little bit with all the people in the meeting. Oh, we can't hear you again. I'm sorry. You can try, if you'd like a question, you can write in the chat. And I could read it out.
Oh, crap.
I'm still not seeing anything. I'm sorry, David. Josh, are you seeing anything in the chat?
I'm not seeing anything. Of course, David could always try calling the number that's on the agenda as well. Unless he's just given up.
You could do that. You could try emailing me as well if you wanted to, and
Yeah.
I could read something out, but okay. All right, he's waving his hands now.
All right, do we have anybody else from the audience?
Hmm.
Okay. If not, we'll now take a vote on deciding if this application will be considered an administrative approval. I need a motion to approve the application of Valley Street Investments for a wedding event facility, IWWC 2122-33, as an administrative approval. Will somebody make that motion?
Mr. Chair, I would just suggest one element is, and the motion could be made to sustain the hearing officer's decision. That's what your regulations say. And then, of course, that motion could fail, and then you could go from there. But a good way to start on an appeal from a decision to approve it is to make a motion to sustain the agent's decision, and that will track the language in your regulation.
Okay. Does
So-
anybody want?
John, this is Ian. I make a motion to sustain Isabel's administrative approval for the application as noted.
Okay,
I'll second it.
all in favor, raise your hand. Opposed? Motion carried unanimously. Thank you.
Thank you for your time this evening.
Good
Yes,
evening, Mr.
thank you
Chair.
as well. Yep,
Good evening, everybody.
good evening. Thank you.
Thank you for coming.
Of course.
Okay, let's continue on our agenda here. We've got one more item to take care of, I know. This is item 7.2, IWWC 2122-37, application of Michael Dobush of 3 Sleepy Hollow LLC for platform to safely cross the ditch between 15 and 19 Sleepy Hollow Road, Assessor's Map 168, lot number 8, I think it's 8011. Isabel, you want to clue us in on that? I know we had a site walk there and everybody got a chance to see it.
We did have a site walk, I believe, again on the 16th, the same date that we had a site walk at 21 Lake Road. And I do see Mike Dobish, the property owner here. I'd just like to say thank you for your patience in this. So the property itself is just a right of way down to Columbia Lake off of Sleepy Hollow Road. Along the side of the right of way, there is an existing drainage swale. The culvert from the road outlets into the swale, and that has been over time causing erosion of the swale and of the right of way to the point where Mr. Dobish felt that it was unsafe for himself and his guests to walk down the path. The right of way in particular, and I know this was a concern of his, is also accessible to, I believe, 7 families. Mike, you can correct me if I'm wrong on that number. So several people along Sleepy Hollow Road have access to this right of way and walk down it to the river. So his concern was really finding a way to make it as safe as possible. There is quite a slope there. It's pretty steep, and the erosion makes that more difficult to traverse. So at this point, some work has occurred without a permit. And that's what the commission was looking at during the site walk last month. Mr. Dobish mortared part of the area closest to the lake by the dock to solidify the stone in the area and direct runoff away from the dock, and then placed a wood bridge path over that. And we had some discussion about potentially that he would like to place a pipe from the road to the end of the I apologize, to the end of the slope and outlet it into the lake. And we've had some back and forth over that. We certainly had back and forth over that at the site walk. Generally, the concern is that we don't allow pipes from the road to outlet directly into the lake. So there's some discussion to be had over the best solution at that particular location in terms of controlling runoff and allowing it to be safe and accessible at the same time. And I think that we didn't really settle on a final solution. So I think that this is something that's going to potentially have to be just further discussed by the commission and updated so that we can finalize a plan to determine the best course of action, because there were a number of options that were discussed at the site walk. And I think primarily we were discussing maintaining that swale a little bit more, refilling it with larger stone, or possibly putting a pipe towards the end of it just to control the erosion at the end, rather than piping it all the way down the slope. So I will pass that on to Mike, and you can add in anything I maybe left out there.
Yeah, I think under this permit, we're just dealing with just the platform I built. I just want to make everybody aware that that rain that we had last Friday night and the Saturday, the water did overrun the swell at the top of the hill and caused additional erosion, on the, coming down the hill. There wasn't the part that I built handled the water fine, and there wasn't any overflowing in that area. But consequently, I have more of a rut that runs alongside the swell. So, as we go on, I think what I'm gonna do is come up with a new drawing and probably a new application for the work that I'd like to do, what we talked about at the site of just doing a pipe, maybe like 35 feet up from the lake and going straight, and entering the lake under the dock. I did touch base with lake management last night, and they expressed that they would rather have the pipe above the water line rather than below the water line, but I don't know whose jurisdiction that actually falls in, and that's beyond my expertise. I know that most of the other pipes are at lake bottom level, it seems, from the pictures I've seen it took, but I don't know if anybody has any input on that before I start doing drawings, but I know right now we're just looking at just the platform.
So
So I guess we should hold off until next meeting. Yes, Mary, do you have something?
yeah, well, I guess if we're only talking about what's currently been done at the bottom of that small hill on the Dobish property, my questions and or comments really are more related to the swale and to any sort of piping. Unfortunately, I missed LMAC last night, so I'm not familiar with what was said, but I'll certainly look at that Zoom and catch up in terms of what was said and or if any decision was made, because we only advised the Board of Selectmen. We would not have made any decision, and or I don't know if there was a motion or a vote to support.
No, there was not. I was just trying to get information, before I did any drawings to what they would want to see.
Well, my only comment would be, And I briefly discussed this with Isabel and gave her example. I understand and respect that the history, Mr. Dobush, that you have presented to us is saying that, there are X number of obviously storm water pipes that enter into the lake. The more current or recent history, and I think John Valenti and Isabel, I would suggest you reach out to him, which would help Mr. Dobush understand, is we have not been allowing pipes. As a matter of fact, there are two relatively newer constructed homes that are only or have swales. One of the swales may have a pipe at the end, which may or may not help Mr. Dobush. But I think we have to consider all of options, not just a pipe. And I would suggest that in more recent construction, there have not been approvals for pipes. There have been approvals for swales. And I know of 3 homes where swales, one with a much more steeper slope, have been approved versus pipes.
But the situation here is I have 15 feet. And how do you safely cross a swale? I mean, that's, I'm open to any suggestion, but we can't have an open ditch for people to constantly cross over.
I believe before you purchased the property for 30 years, that swale existed
No.
and people used it. The same people.
Before, I've been there for 61 years. And when that was grass and the extra culvert that was added on the left-hand side of Sleepy Hollow, which is now pushing additional water down that property, was installed last year. The problem.
Well, I just think we have to look at history in terms of not the history of 30 years ago, but the more recent history and what that does to impact the lake, be it help or not help the lake. So my suggestion be that your permit have options other than pipes. That's just my personal suggestion.
To build,
Excuse me. Oh, go ahead, Ian.
to build on Mary's point, I know, Mr. Jowish, you mentioned that, or we all saw that, this is partially town water as well. Have you started discussions with the town public works to either create a drainage right away or a drainage easement to formally address this?
I was told that I have to go run everything through inland wetlands before.
Well, so ultimately,
The town was unwilling to do anything.
so ultimately,
The
we
town
don't.
manager and the public works director, their last words were, keep me in the loop.
So, I mean, ultimately, inland wetlands doesn't have funding to address this kind of stuff. It's town
Right.
public works, and we would only address a permit. So, I think one of my biggest comments is if we are entertaining a pipe, personally, I would want to see engineered solutions to that with calculations and, taxpayer to taxpayer. If that water is coming from somebody else, I'd want that someone else to be designing that and chipping into that solution.
I would too, but I mean, I would say that recommendation has to come from, I've tried with the town manager and have no success of pushing it forward. Like I said, the last meeting I had with him on site with the public works director, they just said, they offered no solution and said that I needed to go through inland wetlands to do anything. I approached the town with saying my family would buy the materials if the town could put them in. And, that's when we were going with a full pipe. I backtracked, that the pipe, the whole pipe's gone away, and I've come, to the realization that the last, so X amount of feet so that the area going to the dock and to the steps are accessible without a 4-foot ditch by 2 foot deep for people to cross over. I realize you don't have funding, but you can say to the town that this is impacting wetlands, you know, I need some further direction on where to go. You know, ultimately, I gave the Connecticut state statute that says the town is responsible to make the least possible impact to the property owner's property for stormwater runoff, which hasn't been done, you know, and you know, I don't want to get lawyers involved in everything. You know, it's a small town. I want, you know, a simple solution that's comparable to everybody, you know, at the least expense to everybody as well.
Reasonable.
Yeah. Yeah, I agree with Ian. You know, I was going to say something along the same vein. You know, if the town's dumping water on that property, they should be taking part in actually creating a solution for the drainage of the water and have it properly engineered. So I don't know if we can, you know, go back to the town or go back to Steve or whoever, but maybe we could, you know, voice our concerns there.
You know, that would be much appreciated. You know,
Reasonable.
yeah, you know, but I'm trying to, you know, keep things moving too, so that maybe something can be done this season, you know, and I know, you know, it's a process between, you know, showing drawings and getting drawings approved. You know, I would like now to get something so it can be done over the winter.
I would just say, if I can chime in
Yeah.
here, Mike, I think that your current plan of getting the approval for what has been done to date with the bridge work is reasonable. If the commission would like to discuss the work that's currently been completed, and then we can kind of come up with a plan together. I'm happy to work with you, and, you know, maybe I can come out and meet you on the site at another time, and we can go over how to continue on with the rest of the swale and protecting it.
Right.
Whether that's partially piping it and working with the town, maybe to get the pipe sized at least, or finding a solution based on riprap, which I know has been done in other locations. Again, the slope of this one makes it a little bit more challenging.
Or they could pipe it down to the next swell, which doesn't cross any usable property.
Right. So I think that at this stage, if we could maybe, I don't know if the commission has any more questions or discussion that they'd like to have about the work that's been done currently. And then we can kind of either do another application in the future with those other details kind of hammered out a little bit more now that you've had some discussion with commission members, or potentially come back and do an amendment to this application itself again through the commission, just to keep things moving.
Right.
And,
Isabel,
you know,
based on
potentially-
based on your recommendation, I would offer a motion, and I'll leave the wording to you, to accept the current safety plaque that's been put in.
Okay, I do
Bridge.
have a summary ruling prepared.
Thank you. Motion to do
Good,
that.
okay. Why don't you read it?
And
Okay.
I will share my screen. So this is at this stage for the right of way between 15 and 19 Sleepy Hollow Road, IWWC 2122-37. Just for the platform that crosses the existing drainage swale near the dock within the upland review area of the lake. Again, these are the standard conditions of approval. This permit is valid for 2 years or until the work is completed. And beyond that, all activities for the prevention of soil erosion, such as silt fence, hay bales, any other necessary measures required shall be under the direct supervision of the engineer or at the discretion of the wetlands agent, who shall employ best management practices. And Michael Dobish is assigned the responsibility for implementing the sediment and erosion control plan. In this case, there isn't one currently. The work has been completed.
Right.
And there's no further sedimentation that we anticipate coming from the platform that was placed over the swale. And that's all I had for conditions of approval at this time for the work that was completed.
Okay, that sounds great. Thank you. Somebody want to make that motion that Isabel just read?
Motion to approve.
And second,
I'll second it.
all in favor, raise your hand.
Oops.
That was Mary and John Dilworth, right, for the.
Yeah.
Okay.
Yep.
Yep, thank you. We're all set.
All right.
Okay, we're getting there. All right. The next item is approval of the meeting minutes. 8.1 is the regular meeting minutes of June 6, 2022. Somebody want to make that motion?
I'll make the motion.
Okay, second it.
Yep.
Anybody going to second it?
Mary?
I can't. I
Got it,
wasn't
yeah.
at the meeting. I
I'll-
can't. I abstain. I wasn't at the meeting.
Tip is seconding it.
Okay, very good. All in favor, raise your hand.
I abstain.
All right, so moved. And the second second one was 8.2 site walk minutes of June 16th, 2022. Do I have a approval for those minutes?
I'll move that.
Okay.
Second.
Second.
I'll second.
All in favor, raise your hand. Okay, that's approved. Audience of citizens, we've still got that. Anybody want to say anything? I guess we kind of do not have anybody here for that. Commission open discussion. Any open discussion? Nope. Okay.
John, one real quick thing,
Yep.
just based on that, the last permit application. Isabel, do you mind just passing on? I think, I don't, unless the board has any, or if anybody has any issue with it, just our recommendation that the town enter discussions with Mr. Dobish to try to resolve ownership of the water at a minimum.
Sure. Yeah, I can bring that discussion to the table again. And, this will be, like I said, ongoing a little bit because we also have to coordinate, I think, with LMAC, given the proximity of the lake. So,
Okay.
and
Anybody
Tip, did you
else?
have something to say? And
Who is it?
I see Christine, you're muted. Sorry, one second.
Hello, am I being heard, please?
Hi, we
Yes.
can hear you.
We can hear you.
Yes, I just wanted to add a point of information. In terms of working with the town for the right-of-way, the Dobush right-of-way. One of the neighbors who lives on the street brought attention to the fact that when Lake Road was repaved, they did not slope it as they had previously, which assisted in preventing some of the runoff down Sleepy Hollow. So I just wanted to add that, please. Thank you.
So if somebody talks to the town, they can ask them that question.
Yeah, thank you. Thank you for bringing that up. I'll definitely pass that along.
Thank you, Isabel.
Okay, administration reports. Isabel, what do we got?
So I have one, let me see, the application number. I'm sorry, I have too many tabs open and the the meeting packet's so long. Josh, can you correct me on the number? I believe it was for 222 Route 66. Is that right?
Yes, the application number is 212238.
Thank you very much. So this was for a garage at 222 Route 66. The property is right by the CLP property. There are some wetlands in the area on the CLNP property. There appears to be an intermittent stream and there was some wetlands vegetation. The garage itself is on the other side of a stone wall. And it's just a standard metal garage. It's fairly large, but no basement or anything like that. The area is flat and the wetlands are protected additionally by the stone wall. And there is about 45 feet from the wetlands that I saw on the site.
What is the slab for?
It's for a garage.
Oh, I thought
let's see.
you said the garage was already there.
No, the garage will be put in place just on a concrete slab.
Oh, okay. And it's in the wetland
And
area?
it's in the upland review area of the wetlands, but it's protected by a stone wall that's between the wetlands and the proposed location for the garage. And there's also very minimal slope in that area and about 40-45 feet of distance between the wetlands and the proposed location of the garage.
All right. Do you think this requires a site walk?
No, this I did this administratively.
Oh, good. Okay.
I approved it.
Okay.
Thank you.
Thank you. Last item on the agenda, adjournment.
I'll make a motion.
Good, all right, John. Second. Who's gonna second it? Uh-oh, we can't do it because nobody's gonna second it.
Second, third, fourth,
All in
fifth.
favor? Raise your hand. So moved.
right.
Thank you,
All
everybody.
right. Thanks,
Yeah.
folks.
Thank you very much,
Thanks,
everyone.
guys.
Everybody.
I'll tell you.